Good morning, dear friends. Today, under the treatment of various retirement benefits which are conferred on the employees, we will be discussing various features of gratuity which is payable to the employee from the employer, along with the provisions of income tax with regard to its taxability. To start with, the gratuity is a payment which is made by the employer to the employee in recognition of the services which have been rendered by the employee in the past, and it may be received by the employee himself at the time of retirement or superannuation, or it may be received by his legal heirs on event of the death of the employees. So there are two instances when the gratuity is payable. It may be payable to the employee himself, or it may be payable to his legal heirs on the death of the employees. In the first case, it means in this case, when the gratuity is payable to the employee, then it shall be taxable. It shall be taxable under the head salary. So when an employee gets the gratuity on account of his retirement or superannuation or resignation, then the amount of gratuity shall be taxable under the head salary. However, in case the gratuity in respect of the employee is payable to the legal heir of employee at the event of the death of the employee, then it shall be taxable under the head income from other sources. But please remember, under both the cases, whether it is payable to the employee or it is payable to the legal heirs of the employee, under both the circumstances, under both the cases, the amount of gratuity is exempted up to the certain limit as per the provision of subsection 10 of section 10 of the Income Tax Act. So under both the cases, it is exempted up to a certain limit, and after that it is subject to the tax as per the various provisions of the Income Tax Act. So, for the purpose of the exemption of the gratuity, in terms of the subsection 10 of section 10 of the Income Tax Act, the employees can be divided under three categories. It means three categories are there under which we can divide the employees, and based on these categories we can come to know the exemptions of gratuity under subsection 10 of section 10 of the Income Tax Act. The first category is the government employees and the employees of the local authorities. Government employees here means the central government employees, the state government employees, and the employees of the local authorities. If an employee of the government or the employee of the local authority receives any gratuity, then the whole of the gratuity which has been received by him at the time of his superannuation or retirement is totally exempted under clause 1 of subsection 10 of section 10. It is fully exempted. It is fully exempted under section 10 is government employees. So this is fully exempted. Now another category is the employees which are covered under the Payment of Gratuity Act 1972. Now what are those? Who are those employees? We will just try to discuss in detail. First of all, we should know what exactly is a Payment of Gratuity Act 1972. In the year 1972, the Government of India passed an enactment, passed an act which is called the Payment of Gratuity Act. The Payment of Gratuity Act 1972, it was passed by the Government of India. And the next question arises, what exactly is the act and what is the applicability of this act? This act, the Payment of Gratuity Act 1972, is applicable to the following. Means this act is applicable to every factory, to every mine, railway, company, oil field and port. And it is also applicable to every shop or establishment in which 10 or more persons are employed or were employed on any day of the preceding 12 months. So this act is applicable to such establishments. If it happens, if any establishment or shop, it is employing 10 people, 10 employees or more, then the act shall be applicable to such establishment, and accordingly the gratuity shall be payable by such establishment to the employees working therein. So this is the applicability of this act. Now the persons or the employees who are working in the organizations which are covered under the Payment of Gratuity Act, it means the provisions of the Payment of Gratuity Act shall be applicable in respect of the exemption of the gratuity. It means the gratuity which is received by the employees who have been covered under this Payment of Gratuity Act shall be exempted to the extent it has been provided for under the provision of the Payment of Gratuity Act 1972, and the balance amount would be taxable as per the provisions of Income Tax Act 1961. So, in terms of the provisions of subsection 1 of section 4 of the Payment of Gratuity Act 1972, the gratuity is payable to an employee on the termination of his employment after he has rendered a continuous service of not less than 5 years. This is as per subsection 1 of section 4 of the Payment of Gratuity Act. It means an employee who has rendered a continuous service of not less than 5 years, and such termination of employment has been or may be on account of superannuation, or it may be on account of his resignation or retirement, or such a termination of employment is on account of his death or disablement due to accident or disease, then he shall be entitled for the gratuity in terms of the subsection 1 of section 4 of the Payment of Gratuity Act. But here one thing is, you should remember one thing: the applicability of 5 years is not to be applied in the third category when an employee dies or he gets disablement due to accident or disease. In that case, a continuous service of 5 years is not necessary. Except those under both the categories, if a person has rendered a continuous service of not less than 5 years on superannuation or on his retirement or resignation, then he is eligible for the gratuity. This is as per the provisions of the Payment of Gratuity Act as applicable, as governed under subsection 1 of section 4. So this is the entitlement of the employee who is working in an establishment which is subject to the applicability of Payment of Gratuity Act 1972. As I said you earlier, that an employee who is covered under the Payment of Gratuity Act shall enjoy the exemption in respect of the gratuity received by him to the extent it is exempted under the Payment of Gratuity Act. Now, what exactly is the exemption under the Payment of Gratuity Act? It means that exemption would be enjoyed by the employee, and the balance amount, if it exceeds that, it would be taxable under the Income Tax Act. So, as per the provisions of the Payment of Gratuity Act 1972, the least of the following amount is exempt, and the balance is taxable in respect of the gratuity. So, number one is your actual amount received by the employee. It means the least of the following amount shall be exempted. Number two, rupees 3,50,000 or 15 days salary. 15 days salary for each of the completed service, for each year of the completed service or part thereof in excess of 6 months. It means out of these three, least would be exempted. It means the actual amount a person has received as a gratuity, it may be exempted, or it may be subject to a maximum of 3,50,000, or the gratuity may be computed as per the 15 days salary for each year of completed service rendered by him, or part thereof in excess of 6 months. I will just try to explain the meaning of particularly this in excess, part thereof in excess of 6 months. For example, Mr. X, he has been working in a company which is covered under the Payment of Gratuity Act, and he has rendered a service of say 28 years and 7 months in a company. Now he is going to retire. So in this case, the gratuity shall be computed as number of years of service is 28 years. It means 28 years service would be there. Since he has completed more than 6 months of a service, means 28 years and 7 months, in this case he will be entitled for the gratuity which is applicable for the 29 years of service. Had he rendered less than 6 months or 6 months, then he would have been entitled for the gratuity for 28 years of service. Since he has put a service of 28 years and 7 months, so he will be eligible for the gratuity which is equivalent to the 29 year of services. So here it means the least of the following amount would be exempted under the Payment of Gratuity Act. The first is the actual amount received by a person, by the employee. Number two, rupees 3,50,000 means this is the maximum limit which has been prescribed by Government of India. Or it may be 15 days salary for each year of completed service or part thereof in excess of 6 months. So here 2-3 things are important. Number one, the completed year of service, which I have just told you what exactly we mean by the completed year of service. The completed year of service means if the service is 6 months or less than that, then that part of service will be ignored. For example, if a person has put in service of say 25 years and 5 months, then this 5 months that would be ignored. Or if a person has rendered a service of 25 years, 6 months and say 10 days, then this 6 months and 10 days would be reckoned as 1 year, and his total service would be equivalent to 26 years. So this is the meaning of completed year of service or part thereof in excess of 6 months. Next is we have been talking that 15 days salary. 15 days salaries in respect of each year of completed service. Now the question arises, what do you mean by salary? What do we mean by salary? And how the salary should be calculated for the purpose of calculation of gratuity? the term salary has been defined under subsection 3 of section 2 of the Gratuity Act 1972, and as per the provision of section 2, salary means wages means and includes salary also. So as per this definition which has been given by section 2, the term wages means and includes the emoluments which have been earned by the employee while on duty or on leave as per the terms of employment, and includes the dearness allowance. It means it includes the dearness allowance. This is the definition of wages which has been provided by section 2 subsection 3 of section 2 of the Payment of Gratuity Act. Payment of Gratuity Act. It has provided the definition of wages. Since wages include salary also, so we can say the wages means all emoluments which have been earned by the employee on duty, means when he is performing the duty, or which have been earned by him on leave as per the terms and conditions of his appointment. And this wages, they also include the dearness allowance, but does not include what? Does not include number 1, commission. Does not include the bonus. It does not include the house rent allowance. It does not include the overtime allowance. So these things are not included. It does not include other allowances. So the salary means only dearness allowance, but does not include the commission or the house rent or the bonus or the overtime allowance or other allowances. So that is the definition which has been given under subsection 3 of section 2 of the Gratuity Act 1972. So salary here means basic pay plus DA, that would be taken care of while calculating the 15-day salary. So when we calculate the 15-day salary, so we'll be just taking the basic pay and DA, and the salary would be in terms of the salary which has been defined under this section. The third important thing to be noted in this calculation of gratuity is the monthly rated employees. In the case of monthly rated employees, where the employee has been given the salary on monthly basis, then the 15-day salary shall be computed like this. In the case of monthly rated employees, the number of days in a month shall be deemed to be 26. It means if a person, the number of days shall be equal to, it means if a person has rendered a continuous service of say 25 years and 7 months, and how his salary would be calculated, we assume that his salary as per the Payment of Gratuity Act is say 10,000 rupees per month. 10,000 rupees per month. How the 15-day salary for each year of completed year of service put in by him would be calculated. It means 10,000 rupees multiplied by 26, because this is 26 years of service. He has put in 25 years plus 7 months. 7 months means it's more than 6 months. Then it would be taken as 1 year. 7 months would be equivalent to 1 year. So total number of service would be 26 years into 15 days salary. It means we are just taking 15 days salary for each year of completed service, and the number of days in a month shall be deemed to be 26. So that would be divided by 26. So the total amount of gratuity as per this would be 1,50,000. This is the meaning of the term salary here, monthly rate employees. However, this 15-day salary is to be calculated in respect of those organizations which are not seasonal in nature. However, when an employee is working in an organization which is covered under the Payment of Gratuity Act, but in which the work is on seasonal basis, then in that case the gratuity shall be calculated based on the 7-day salary for each of the seasons. It means we have to see the number of seasons in a year, and based on that we can calculate the gratuity, which is as per the 7 days salaries, 7 days average salary. So here the 7 days average salary shall be the salary which is based on the average of salary drawn by the employee during a period of 3 months immediately before preceding that event. So in this case, the 7-day salary would be calculated in the case of seasonal factories, a seasonal organization where a person is not employed for the whole part of the year, rather he is employed for the seasons. So in this case, we will be just taking the seasons, and based on that, the gratuity would be calculated on 7 days average salary. Average salary means the average which is taken based on the average of 3 months salary drawn by him immediately preceding his termination or immediately preceding his this particular event. And in the case of peace-related employees, means where a person is not being paid on the monthly basis, whereas he is paid on the peace-related basis, the daily wage means daily average salary would be calculated based on 3 months average salary, based on average of 3 months salary drawn by him immediately preceding such event. The third category of employees are other employees, means those employees which are neither government employees which are not covered under the Payment of Gratuity Act. It means what would be the exempted amount of gratuity in respect of those employees. Here again, those employees which are not covered under the Payment of Gratuity Act, and they are also not government servants as in the first category. In this case, the least of the following shall be exempted, and the rest would be chargeable to income tax. So the first point is the actual amount of gratuity received by them, or rupees 3,50,000, or half month salary for each year of completed service. If we are just trying to make a comparison between the employees which are covered under the Payment of Gratuity Act and those employees which are not covered under the Payment of Gratuity Act, means other employees, we will just find the difference between the last clause which has been mentioned in the prior category. Here they will be entitled for half month salary for each year of completed service. Here the completed service means the fraction of the service will be ignored, which means if a person has put in say 27 years of service, 27 years and 10 months, then these 10 months would be ignored. It means the part of the services that would be ignored, only the total number of completed years of service would be taken into account for the purpose of calculation of gratuity. Number 2, here we will be taking half month's average salary. Half month's average salary shall be based on the average of the salary which is drawn by the employee during a period of 10 months immediately preceding the month in which such an event has taken place. For example, if a person has been superannuated, say on 2nd January 2007, then the 10-month salary shall be taken from 1st of April 2006 to 31st of means 10 months beginning from 30th December 2006 towards that, means we just take the 10 months average salary which will end on 31st December 2006. So we will be taking 10 months salary immediately preceding the month in which such an event has taken place. So first of all, under this case, when an employee is not covered under the payment of gratuity act, so we will be taking actual amount of gratuity received by him, or rupees 3,50,000 or half month's average salary for each year of completed service. And the completed service only, it means the part of the service which may be in months, that would be ignored. Even if a person has completed say 27 years and 11 months, then 11 months would be ignored. Only 27 years service would be taken care of. That would be reckoned for the purpose of calculation of gratuity. So the least of the amount shall be exempted, and the balance would be taxable as per the provision of Income Tax Act. Thank you very much.